is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning, and welcome to all who are here in person and those who are viewing on the live stream. We're so pleased to have all of you. We have two very interesting cases today that unfortunately two of our regular colleagues are not participating in, but we are blessed to have two of our finest appellate judges sitting with the court this morning. First is Judge Ross Dyer from the Court of Criminal Appeals, and then Judge Jeffrey Usman from our Court of Appeals. The court is so grateful to have them, and so it's going to be a particularly interesting oral argument for the lawyers. I know you are up to the challenge. I will say, tell everybody that I've got a really bad cough, so you will see me with throat lozenges. No disrespect intended. So, are there any preliminary matters before we call the first case?
No.
All right, you may call the first case.
Alan C. Cartwright versus Thomason, Hendrix, PC et al.
Good morning, Mr. Duncan.
Madam Chief Justice, Associate Justices, and Special Justices, may it please the court. Tony Duncan, the Nashville Bar. I represent Alan C. Cartwright, who is the plaintiff appellant in this case. This time I'd like to reserve 8 minutes for rebuttal. Before I begin, does the court have any questions about anything? Or does it have any topic it would like for me to address at the outset?
I think you can launch into it with the expectation that we have read your briefs and are familiar with the facts.
Thank you. Mr. Cartwright is respectfully asking this court to reverse the Court of Appeals judgment and reinstate the trial court's judgment that denied the petitioner's TPPA petition below, TPPA being Tennessee Public Participation Act. It is Mr. Cartwright's position that Judge Davies was correct in his ruling, and I'm prepared to explain why today. So, because we're dealing with statutory construction and interpretation, we're dealing with an issue of law, which is de novo, with no presumption of correctness to the lower court's decisions. So, before I get to the heart of the matter and the question presented, I would like to address one preliminary matter. That this is a legal malpractice case. Now, my opponents want to cast it in some other light and act like it's not, but it is a legal malpractice case. It has been pleaded as such: duty, breach of duty, causation, both factual and legal, and damages. And matter of fact, to the damages, part of them was...
Let me mention, Mr. Duncan, as you are standing in that well, you will hear an echo. We don't hear that. So I think you can bring the microphone close to you. And I'm sorry, it's a little disorienting if you're the lawyer standing there.
Okay.
Nobody else hears that except
so
you. So you need not worry about it.
I didn't want to be...
No, you're not.
Okay.
You're not. And we do want everybody on the live stream to pick up on what you are saying. So if you can, put that to one side and don't worry about it.
Okay. Yes, Your Honor. But we had, all the elements have been pleaded, and specifically to damages. The defendants here, during an oral argument in the Sixth Circuit, and the Sixth Circuit, when the panel posed a question, well, what would keep you from us dismissing these cases and you refiling them in state court? It was admitted they would be time barred. They refiled those cases after they were dismissed from the Sixth Circuit. And that's what subjected Mr. Cartwright to the attorney's fees and the cost, expenses, and the fines that he suffered. So that's an imposition of liability under Austin versus Sneed. That's a cognizable or recognized element of damages. So we have a legal malpractice case here. So anytime my opponent, who's my friend, tries to have this court look at it and treat it like some other case, it's not. It's come back to the fact it's as immutable as gravity. It's a legal malpractice case. Now, when I left church on Sunday, my mind was racing. trying to think, what did I want to, in essence, lead with? And I think, especially after Smith, that we need to lead with the right to petition. So, in this case, the defendants have claimed that they have been sued for the exercise of the right to petition that's recognized under the TPPA. Respectfully, that is not the case. As this court recently held in Smith, under Article 1, Section 23 of the Tennessee Constitution, that right to petition is only enforceable against a governmental entity, not a private entity, private party. The cases below that birthed these legal malpractice cases were trust cases between and among family members and private parties. There was no right to petition in those underlying cases as recognized under the petition clause of the First Amendment of the United States Constitution or Article 1, Section 23 being asserted.
Counsel, isn't the petitioning to the court, though, and the court is very much a governmental entity?
It is, but traditionally that is not, lawsuits have never been considered. I'll back up a little bit. To answer your question, under the First Amendment of the Petition Clause, Justice Scalia in Borough of Duryea versus Guarnieri on page 420 of that opinion, I believe, in his partial dissent, noted that the U.S. Supreme Court has never recognized that lawsuits were petitions.
But that was a partial dissent.
That was a partial dissent.
That was not the majority opinion.
Correct, you're right. But he did point that out and said that those cases are dicta, but he's right in that observation. And also,
Well, why is he right in that observation? And we have to look both at the United States Constitution and the Tennessee Constitution, because the TPPA defines the right to petition with reference to both federal and state constitutions.
well, even if a lawsuit was a petition, right, it would be, we would submit that would have to be, to qualify under Article 1, Section 23, have to be directed at some sort of governmental entity, some
Well,
governmental
why is
entity.
a court not a governmental entity?
Well, that's just the conduit that those rights would be enforced through.
But it's asking the court, a litigation, a lawsuit is asking the court to take action. It's asking the court to redress a grievance, isn't it?
It is, but.
So how does that not fall within either the federal or state or both constitutions?
Because if you're dealing with private parties, then that's not how the right to petition has been traditionally recognized historically. From one of the law review articles cited in Smith, it talks about the right to petition, and it goes all the way back to 1103 or 1113 or 1013. Appellant the second.
Hasn't the U.S. Supreme Court rejected the argument, though, that courts are not state actors? I mean, we can look at jury selection cases, we can look at issues in terms of racially restrictive covenants. When you come into court and ask for a court order, that's governmental action that's occurring, and that's the basis of state action in those types of cases. And this is a governmental actor that's being asked to do something.
Well, it's being asked to enforce the right between private parties.
Just like with racially restrictive covenants.
That's true, but you got, under Article 1, Section 23, like as Smith points out sometimes, you've got some constitutional rights that could be enforced against private parties. So in Tennessee Constitution, slavery's been abolished, and involuntary servitude, those can be enforced against private parties. Article 1, Section 23 cannot be. That's kind of the distinction here. So,
Well, but they're not trying, nobody's trying to enforce the right to, this is about whether the act of filing a lawsuit in a court, I'm just gonna look at the language of the Tennessee Constitution, it constitutes applying to those invested with the powers of government for redress of grievances. Would you agree that a court is invested with the powers of government?
to an extent under our Constitution, yes.
Well, I mean, that's how we have our authority, right? Is that
Correct.
the Constitution vests us with governmental authority. And it's, go ahead.
That's okay. I was just saying, Mr. Duggan, let me take you to where down the path I see your interpretation taking us. And that is, how would the TPPA ever apply to any lawsuit that involve private parties?
I don't know if well, it depends. Now, it might because Bob Boston addressed this in the Smith during the oral argument. But the distinction here is that, so the claimed right being asserted here is that the defendants are saying that they were exercising their right to petition, because a right can't exist.
Their right to petition, but your argument is the right to petition is only enforceable against the government and not between private parties, correct?
Not always. That's a distinction I'm trying to draw here, is that there might be times when that is, and we talked about this with Judge Davies, but the claimed right here is under the petition clause of the First Amendment and Article 1, Section 23, the right to petition. So traditionally, that has always been when one is trying to petition the government for the redress of grievances, and that language is in the Act. And matter of fact, in TCA 20-17-102, it limits the rights protected under the TPPA to Article 1, Sections 19 and 23 of the Tennessee Constitution and the First Amendment. The rights that defendants have claimed here are the right to petition. And in this case, the right to petition would be, as this court recognized in Smith, to petition the government for grievances. So a lawsuit may actually do that. In this instance here, a lawsuit may be a petition somewhere else, but in this case, the underlying lawsuits, the trust lawsuits, weren't petitions for seeking redress for grievances and seeking the redress.
It was a private grievance. I mean, the language doesn't say it has to be for redress of a public grievance. I mean, I take your point that that there couldn't be a lawsuit, against against the Mitchells for violating the right to petition. They are not government actors. But the whole point of the TPPA is to provide protection against private actors who are trying to chill activity that is constitutionally protected. I mean, you're sort of saying that there has to be that the plaintiff would have to be able to kind of assert a constitutional claim against the actor who is chilling their speech in order to invoke the protection of the TPPA. But that's not the point of the TPPA. I mean, this is a situation where the legislature was trying to kind of provide an avenue to prevent private parties from chilling constitutionally protected speech. I mean, if the legislature in the Smith case, right, the legislature could enact a cause of action allowing employees to assert retaliatory discharge claims against their employers if the employers are interfering with their right to petition.
They chose not to.
The problem in Smith was that they hadn't done that. So I guess I'm just not completely following your train of thought as to why this doesn't fall within the right to petition. And it might be helpful, I mean, unless anybody else has questions, it might be helpful to sort of move on to what I think is perhaps a stronger argument on your side, which is that it has to be, that the lawsuit has to be filed in response to or related to the party's exercise of the right to petition.
Correct.
So why don't you, unless, if anyone else has questions about, whether this falls within the right to petition, we can certainly go back to that. But I'm curious about your argument as to why this is not the Mitchell's exercise of their right to petition.
Correct. All right, thank you. So if you look at the Act, when the TPPA was enacted in 2019, it's relatively new, it's a nascent law. But it talks about the enforcement of a person's rights, and these rights have to be personal. Like, rights can't exist, like I said earlier, out in ether. Like, someone has to have them to be able to exercise them, right? For a right to be exercised, a person has to do it. So the lawsuits below, let's assume that for purposes of the TPPA, purposes of argument, that a lawsuit would be a petition that would fall under the TPPA. Even if that were true, which we'd submit in this case it's not, but even if it were true, who's exercising that right? Because here, we've got this lawsuit between and among private parties and family members. and there are trust lawsuits. So this, if it is a right, in this case, the underlying lawsuits, the trust lawsuits would have been Mr. Cartwright's, my client's, be his. But, and here's why, in part, is that as a matter of law, and that's what we have to decide here, is what the law is. Is it under TCA 20, let me make sure I got it, 23-3-101, is that an attorney representing the client is not exercising their own rights. They're acting as a representative for that client who is asserting his or her rights. And another point is that this court's two opinions, Milligan versus Board of Professional Responsibility, 301 Southwest 3rd, 619, page 630. And also Sneed versus Board of Professional Responsibility, 301 Southwest 3rd, 603, 618. Both talk about, Sneed cites approvingly Milligan. And Milligan is very clear that a license to practice law in Tennessee is not a right, it's a privilege. So you have someone who's practicing law under not a right, but a privilege, and they're representing someone else in a lawsuit.
Counsel?
But under your theory, then, are you not eliminating the TPPA as a defense in a malpractice case forever? Which the legislature could have done, like other legislatures have done, when they've gone back and rewritten it, because you're saying that a lawyer who's acting as an agent of your client, or of a client, it's not his right, and therefore you could never use this to defend against a frivolous malpractice claim. You'd actually have to take the malpractice claim to its ultimate conclusion, even if it's completely frivolous, because you can't use this as a defense to dismiss it.
Not always, not that broad, and Judge Davies and I talked about that, but in this case, when you have someone's claiming, the right they're claiming is the right to petition. So in this limited circumstance, that an attorney who's sued for malpractice can't use the TPPA to say, I was exercising my right to petition, ergo.
How could he use the TPPA then? How else could he use it?
For instance, there's a couple of cases. There's that USA lending case, I think, and there's the Youngkin case. These are Texas cases. But you might have a lawyer that exercises another First Amendment right, or right of assembly, or right of speech. Maybe gets sued for that.
Counsel, it seems to me that in looking at the definition in 103 of exercise the right of petition, looks like there are three components, right? You need a communication. That communication needs to fall within the protection of the United States Constitution or the Tennessee Constitution, and then, depending on which route you're traveling, either A or B, is intended to encourage consideration of review of an issue by federal, state, local, legislative, executive, judicial, or other governmental body. I'm missing the word his or my in there. And so if we look at this, it's a communication. The communication is a form of petition, which, if it's a petitioning activity, falls within the protection of the United States Constitution or Tennessee Constitution, and it's intended to encourage consideration or review by a judicial body. And so where are we getting the idea that it has to be my right? I mean, it seems like we're adding a word in there that isn't expressly stated in the statute.
Well, if you go back and look at 2017-102, it says the purpose of the chapter. The purpose of this chapter is to encourage and safeguard the constitutional rights of persons to petition, to speak freely, to associate freely, and participate in government, ellipse, ... So.
Well, aren't you relying on 105A, that party's exercise of the right to free speech, right to petition, or right of association? Maybe I'm misunderstanding your argument, so I just wanted to clarify. I thought that was your argument, that...
Under impaired material, I mean, we're looking at the whole act here. So, I mean, you can't look at a statute in a vacuum.
Well, no.
So,
I mean, just
but
for
yeah.
the point that it has to be the attorney's exercise of, and when you're talking about litigation and you're alleging that a lawsuit was filed in response to, someone's the exercise of the right to petition in the context of a lawsuit, that when it says that party's exercise of the right to free speech, right to petition, or right of association, if the lawsuit is brought against the attorney, like a malpractice malpractice action, then that party would be the attorney. Maybe, I might be misunderstanding your argument, so please do correct me if I'm wrong.
The TPPA, its text is pretty clear that it says it's not meant to create any new cause of action or alter any existing causes of action or claims, right? So, and it's meant to supplement existing claims or existing law. It's not meant to create anything new. We're not bringing anything from whole cloth. So it's primarily enacted to prevent slap suits. This isn't a slap suit, for one. But also, before the TPPA was enacted in 2019, would these defendants have any rights under the petition clause of the First Amendment or Article 1, Section 23 of the Tennessee Constitution as a defense in this malpractice lawsuit? Because the TPPA is clear about that it has to, they're not creating anything new. It has to exist before the enactment of that act. And we would submit that they wouldn't. Not here, they wouldn't have had a right to petition. They wouldn't have had the right to use the right to petition as a defense in a legal malpractice case before the TPPA was enacted. And I think the statute's clear about that. The legislative history's clear about that. So,
I don't know that that answers my question, but it may just not have been a good question. I think you might be overcomplicating it a little bit. I'm just trying to point you to the text itself of the statute. Like, what is the textual basis for your argument that it has to be the attorney's right to petition instead of his or her client's?
Oh, well, so I may have been glossing over that, but, so subsection A, that last clause in subsection A, it says, or is in response to that party.
You're in 2017-105,
Correct, yes.
subsection A.
So the petitioning party, which would be the defendant here, has the burden of making a prima facie case that a legal action against the petitioning party is based on, relates to, or is in response to that party's exercise of the right to free speech, the right to petition, or the right of association. So here, the defense are claiming that they're being sued based upon the exercise of their right to petition. Even if they want to limit it and they want to change a personal pronoun to an indefinite article and go from there to the, from their right to petition to the right to petition, it's still, this court has to look at whose right was being exercised in those underlying lawsuits. That's why, I guess maybe I glossed over that because I always kind of thought that was just kind of there, right? Like, so obvious it would just jump out at you, although I know.
Well, don't gloss over it.
Yes. But I'm the world's worst at this, so you open the fridge up and you're looking for the milk or Diet Coke or whatever, and it's right there, and I'm everywhere else, the door, the bottom, and it's right there. So, but the point is whose right was being, whose right to petition under, assuming a lawsuit is considered a petition. Whose right to petition was being exercised in the underlying trust lawsuits? And as a matter of law, it could not have been the attorneys who committed a malpractice. And if you think about it too, think about the problems it would cause, and I don't think the legislature intended this, is that let's say someone files a lawsuit, but they file it too late. They missed the statute by a day. And then they get sued for malpractice. That's so obvious, that's considered a common knowledge exception to the requirement of expert testimony. It's so obvious, you missed the statute.
This isn't about who the right defendant is in the malpractice action. We're really just talking about, you know, you could have, I mean, it's possible, right, that it's both the client and the attorney's exercise of the right to petition. So I guess I see that you're out of time with the chief's permission.
You can certainly answer a justice's question.
But so what's your best authority? What's your best legal authority for your argument that it's the client's right to petition and not the attorney's right to petition, at least on the facts of this case?
Article 1 of the Tennessee Constitution, Section 23, the petition clause of the United States Constitution,
Is there any
and
case law that supports your
Pardon?
argument? Is there any case law from this jurisdiction or other jurisdictions that supports your argument?
not that I'm aware of it, I'm not aware of anybody really making kind of this argument here that under Tennessee law either. So, but when you look at the fact that it was a representative, they weren't exercising their own rights. They just weren't below. Had they been, the TPA might apply. Like, this is one thing that I talked about with Judge Davies, that there might be an instance where the TPA might apply to a legal malpractice case. But in this instance, under this set of facts, it's not the case. And I'll yield the floor and I'll be back for rebuttal. Ma'am.
Thank you, Mr. Duncan.
Members of the court, good morning. I'm Lucian Parra. I'm representing the defendant lawyers and law firms in this matter. First of all, it's good to have the court in West Tennessee, so it's good to be with you here. It's a little unusual experience for me since I'm used to being in front of a different set of judges in front of in this room. I want to try to focus the court on the plain language of the statute. I think that's really what's going on here. But before I do that, let me touch on a couple of things. One is the nature of the claims brought against my clients. I want to be very clear that our view is that these are precisely the type of claims. This is precisely the type of action that the TPPA was addressed at. We believe Mr. Cartwright's claims are baseless. They're baseless largely because they're squarely contradicted by his own sworn admissions in the underlying litigation and his testimony. I should say, by the way, I'm sure you noted in Judge Stafford's opinion that he has said, the court held, no court's ever held that the claims in the underlying lawsuits were frivolous. So we may hear in today's argument something more about that, about the claims my client brought. But in any event, the other thing I want to get to before I lose the thread is the Smith versus Blue Cross case. I know this ties in different places, but let me say a few words about that. To be clear, while that decision has a really interesting portion of it, or a large part of it, that's devoted to the history of the right to petition, dating, I think, back to before Magna Carta, where I know I learned a few things. It just doesn't inform this court's work in this case, in these two cases, by the way. First, as to Mr. Cartwright's case, he's never contested, up until perhaps today, and I'm not sure if he contests it today, that the current suit was, quote, filed in response to my client's conduct as his attorneys in, and these are his words, filing and maintaining the 5th and 6th trust lawsuits for him. So he can't contest, really, that the filing of these suits was an exercise of the right to petition. And certainly nothing in Heather Smith versus Blue Cross supports that or casting doubts on that. And as to whose rights, I want to come back to that later, but as to the Heather Smith case, as to whose right to petition was involved, and we say it doesn't matter. That's what not spoiler alert, I'm going to say that again, just as I said it in my brief, but we say it doesn't matter under the plain language of the statute, but in Heather Smith, there was no lawyer involved in the petitioning in the Heather Smith case. This was her addressing the legislature, and besides, as the court pointed out, both in the main decision and in the concurrence, the fact is that this was a common law retaliatory discharge case, not as here involving a statute passed by the legislature. So let me turn back to the plain language, or turn to the plain language. Now we all know that the TPPA is intended to provide a new procedural mechanism, one previously unknown to Tennessee law, to protect against and punish certain kinds of abusive litigation, but to handle them in a particular procedural way that was unknown to Tennessee law before. We say that under the plain language, Mr. Cartwright's suit was one of those. First, look at the purpose. The purpose 20-17-102, which they have cited repeatedly, one of the purposes is to encourage and safeguard the constitutional right of persons to petition. And the very same section talks about broad construction. There's a mandate to this court to broadly construe the statute for that purpose. And it's clearly a procedural statute, right? And it's only designed to single out that specific kind of case and tell the courts how to handle that kind of case more quickly, more expeditiously, in order to protect certain litigants, those who fit this category, from costly litigation and especially discovery. And to be clear, now I'm not sure that I quite heard Mr. Duncan say it today, but he said it in his briefs. It's the case that nothing in the statute repeals any cause of action or limits any plaintiff's substantive rights. That's explicit in the statute. And so no matter how many times Mr. Duncan has said in his briefing that the Court of Appeals decision abolishes a right to legal malpractice actions, that's just not the case. Now let me turn to the central provision here, which is 2017-104A. It's already been discussed a bit, but it says, if a legal action is filed in response to a party's exercise of the right to petition, that party may petition the court to dismiss the legal action. That's what all this turns on. That is what this case is about. So let's look at filed in response to, that language. Was Mr. Cartwright's, the type of lawsuit, type of legal action described here? It was. The trial court and the Court of Appeals agreed about this. They both agreed about this, even the trial court, and they were right. And frankly, up until perhaps today, I don't see the plaintiff disputing that in their briefing. And to remind the court what the trial court said, they said, the trial court said, an attorney who files pleadings or makes statements on behalf of a client in court is exercising the right to petition. I don't think that can seriously be contested. What plaintiff alleges here is that what my clients did wrong was filing and maintaining 2 lawsuits, okay? The 5th and 6th trust lawsuits. So candidly, I just don't see a plausible argument.
Let me ask some practical, practical type of questions. Are you saying that anytime an attorney files any legal action, that is an exercise of the right to petition?
By the attorney. Right.
Well, if I can answer those separately, I don't see how it would not be. I mean, I'm trained to address my client's case before this court, but I don't see how it could not be.
All right,
for a second? I'm sorry.
Oh, no, I have questions.
Okay, but I want to make sure I answer Justice.
All right, go ahead and answer Justice Bivens' question.
I think that as a matter intellectually, that it's both the client and the lawyer with that right. I don't think it matters under the TPPA.
Okay, so it's double.
Yes,
Every lawsuit that is filed is a double exercise of the right to petition of the underlying party and the lawyer who represents that party. Does it apply to individual pleadings? If I have filed a lawsuit and the other side files motion to dismiss the lawsuit, does it apply to the motion to dismiss? You're asking a court to take action. Dismiss that lawsuit, court, please.
I'm not sure why it wouldn't.
Okay. Discovery disputes. Your Honor, please make him answer my interrogatories. That is an exercise of the right to petition, correct?
I think so. Yes, I think so.
So Mr. Duncan could file a TPPA lawsuit claim back against you in this action. Is that correct?
Let's think about that. Well, there are 2 things I'm trying to sort out in my mind. One is, does this fall under the definition of legal action? The definition in the statute looks a lot more...
Well, you just said even asking a court to enforce discovery.
You're right.
Would be
That's
exercising the right to petition.
I'm reconsidering what I just said. But,
You see where I'm going?
Well,
I'm trying to figure out how high does this Jenga go before it collapses? Because obviously, we look at the plain language of the statute, but we have to project out and see how far it goes. I'm not seeing an end to your logic.
well, Your Honor, first of all, I may have been wrong 2 minutes ago. I don't think it's necessary to reach that question to decide today's case. Secondly, one reason I might be wrong is because the answer to your question may well lie, and I hadn't considered it until this moment, in the definition of legal action. A legal action is required for the other side to have a right. Am I filing a legal action, meaning a claim, cause of action, petition, cross-claim or counterclaim, or any request for legal or equitable relief initiated against a private party? Am I doing that in filing a motion for discovery, a motion to compel? That seems like a stretch to me.
Is that not legal relief?
It is. Look, I don't know the answer to the question, is the honest answer, Judge. I just don't know. I don't think that this court is required today and for all time to decide.
Certainly, we are not required to answer all those questions, but certainly we have to project out the logical, what are the limitations here? And I'm not seeing any. Now, maybe that doesn't preclude us from saying, well, that's what the language of the statute says, so I guess, but we also have to figure out where it's going to go.
No, I understand the court's point. I guess my view is fairly simple, and that is, I do think, in a proper case or even here, this court could address the question of whether legal action includes every motion, indeed every request, every oral request to a court for relief in mid-trial. I think the court could address that, and I think the court could conceivably come to the conclusion
How does that not fall within the plain language as you are interpreting it?
I'm not sure it does fall within the plain language. I think it's probably likelier that legal action looks more like the definition of a pleading, an actual pleading in the Rules of Civil Procedure. But again, I meaning no disrespect, my client is not filing a TPPA petition grounded on some, third order, minor, oral, inadvertent, I don't know, whatever, some small request for relief. I mean, that's not what's going on here, Your Honor. And I don't think my clients ought to be denied the ability to use the TPPA for fear that some future party is going to use it based on a motion in limine orally made in the middle of trial. I mean, no disrespect to that.
Let me follow through then in a little different context. If we accept your interpretation, every single legal malpractice action filed in the state of Tennessee would be subject to the TPPA, correct?
No.
Okay, give me an example of what wouldn't.
Anyone that arose in a transactional context. You're assuming all legal malpractice involves litigation. It certainly does not. There are other, I'm not convinced even that every legal malpractice action arising in litigation is founded upon the right to petition. I mean, there are some mistakes we make that we can be answerable for in legal malpractice that are not necessarily about the right to petition. Here, it squarely was. So that's the best answer I can give you, but it certainly wouldn't apply to, I don't think it would apply to a lawyer who, drew up a deed wrong. I don't think. I don't know what constitutional right or right to petition or right of association or whatever that would trigger.
You suggest the attorney has a right, and reference Button in support of that conclusion. I'm curious, how do you get from Button to the conclusion that the attorney has a right to petition? I mean, isn't Button really a case about attorney solicitation of clients?
Yes, and I'm sorry.
I mean, isn't that the right that's at issue in Button? It seems like a stretch to take that to the attorney has a right to petition based upon the Button
Well,
case.
I mean, I read the language of the court. I could pull it, but the language of the court specifically cites, number one, that it's the right to petition that's involved here and involved in that case. And secondly, it's clearly, and candidly, it was only a couple of years ago that I realized this, but the two, lawyers, the lawyers for the NAACP and the NAACP Legal Defense Fund were both specifically mentioned as having the right to petition. And that's because at least the Legal Defense Fund, I think the NAACP too, was for those purposes a law firm. They employed lawyers.
The Virginia statute that's at issue in that case, though, is a solicitation statute,
Yes,
right? It's a
well,
preclusion
that
law,
and some
and
other things, runners and cappers and stuff. Yes,
and
Your Honor.
that's what's before the court in the case, right?
That's
The
right.
attorneys are trying to go out and get clients to file actions, and can they communicate or speak to them?
Right, but I think what you have to recognize in that decision is that the court is saying that's a right. I don't know what the right adjective is, but a pertinent to, sitting next to, included in the right to petition.
But in any action where a lawyer is filing something, your briefs to us today say, the Mitchells say this, the Mitchells say that. How are you exercising your own right to petition if you're, so clearly in a representative capacity? You are speaking, your client says X, your client argues X. How is that an exercise of the attorney's right to petition?
I think it is because, as Mr. Duncan has so eloquently pointed out, we lawyers have a right to do this. We have a specific legal authority to do this.
You have a privilege to do this. You have a privilege to do this.
have-
The practice of law is a privilege.
With all due respect, it is a privilege, but it's a privilege that comes with certain rights, okay? if this court were to say, find me in contempt for what I'm doing here today, then I would have a right to certain things like due process. There's no question lawyers have rights. This court has issued many opinions in the disciplinary process about lawyers having rights, even though the license is a privilege. It can be both.
But you don't have a right to file a lawsuit on behalf of Joe Smith unless Joe Smith retains you.
Oh, of course. I'm not disputing that.
So it's Joe Smith's right to petition the government. It's not your right to petition the government. You're just acting as an agent.
I do agree that you can't, a lawyer is almost nothing without a client, but a lawyer with a client has, in my opinion, both those rights. Let me repeat, I don't think the specific language of the statute, we've argued this in our brief, I think the specific language of the statute clearly allows this court to resolve this question without deciding that really fascinating case. I mean, the court, every member of this court I think knows, if anybody in the world is, I'm an ethics nerd. I would love to have that fascinating intellectual decision decided with as much grace and intelligence and, as it could be. It doesn't have to be decided here because the statute, the legislature has not required that in this context, my clients be exercising their own right to petition. That is not what the statute says, respectfully.
You're based on the fact that it says the right to petition. Is that what you're keying off of?
I'm sorry.
Is that what the language that you're keying off of?
It is. The fact that it omits any word like there or something like that defines.
That's reading an awful lot into an article.
Yeah, and what about the language in 105A
Sure.
that says that it's a legal action that is based on, relates to, or is in response to that party's exercise of the right to free speech? How do you get around that?
Sure, happy to talk about that. 104, before we get to 105, 104 is the central provision. It says who may file a petition. There can be no doubt about that, okay? And it doesn't talk about that parties, okay?
Well, it
Further,
does, actually. It says that party may petition the court to dismiss the legal action. I mean, we're talking about the person who is seeking dismissal of the petition.
Your Honor,
And then
nothing.
105A uses that very language to modify the exercise of the right to petition.
I mean,
That
doesn't our
parties-
interpretation of the word "the," isn't that cabined by the remaining language in the statute? It's certainly at least informed by it.
In general, certainly. I completely agree. But I would point the court out, the Justice pointed to Section 105. I would point out again that the word the Chief Justice just mentioned is present as the only modifier to the right to in 2017 105A. Words matter. Words matter. And by the way,
How does that help your argument, though? I'm not following that.
because it's that party's exercise of the right to free speech, not that party's exercise of their
What
right to
other
free
article
speech.
are you going to put there?
I just mentioned one.
Somebody's, or, I
Yes,
mean,
Your
I
Honor.
don't understand, I'm not
Yes, Your
following
Honor.
that.
What I'm
That's
suggesting is,
entirely unnecessary, given that it says that party's exercise. I mean, I don't understand, how could that party, how could a party be exercising someone else's right?
I'm only here today by virtue of that fact. I would not be before you if I were not authorized by this court and my client to speak for them. So I am exercising their rights. I mean, if I had a power of attorney from a client to execute a document, I would be exercising their rights. This is, I don't mean to disparage the argument, but I think it's clearly the case that it matters whose rights these are. And by the way, it has other implications as far as legal malpractice cases, which, again, I don't want to jump too quickly off of your question, but what I'd like to...
Well, let me,
Sure.
before we,
Sure.
I do want to ask a question before you kind of move on to a different argument. I think I see your point about the Article V, so thank you for clarifying that. I don't know that I agree with it, but I do, I think, understand your argument. I do want to talk about your characterization of Button. I mean, you read Button quite broadly, and I think most courts, since that case was decided, have read it quite a bit more narrowly. And I'd like for you specifically to address the Second Circuit's decision in Jacoby and Myers, which reads Button more narrowly and, says that the Supreme Court has never held that attorneys have their own First Amendment right as attorneys to associate or their own right to petition the government, and kind of draws this line that, at least with respect to speech and association, an attorney might, in some cases, also be exercising their own right if they are, basically, if they sort of believe, whatever they're advocating to the court, and they share in that interest. And so in some sorts of litigation, you might have the attorneys really exercising their own rights, but not in kind of the mine run commercial litigation that's brought by a law firm on behalf of paying clients. I mean, why isn't that the right way to read Button and similar cases?
Well, I'm not sure I'm prepared to take apart the Jacoby and Myers case in front of you right this moment, Your Honor. Frankly, I'm not as prepared as I should be on that, but I will say that I don't understand, I've said this before, and meaning no disrespect to the question, I don't believe the court needs to decide that. If my clients were only exercising Mr. Cartwright's rights, I think that's sufficient for the TPPA to apply. It's just that simple. Now, again, I
understand that argument, but, if you don't have a specific response to Jacoby,
I really
know,
don't,
that's
to be
fine.
honest, Your Honor.
But yeah, I think I do understand your argument that
And I will
the
say,
language doesn't necessarily require us to decide that.
and I will say, if anything, it's unsettled. If anything, the right of a lawyer independently, or independently is not the word, concurrently, to have a right to petition along with the client, I don't think it's at all settled. I just don't think it's at all settled. I do agree that Button, you could argue that I'm pushing it because most people don't read it for that purpose.
You didn't mean that pun, did you?
Puns are the lowest form of humor. I try to avoid them, but.
Sorry about that.
It's all right, it's all right. But I will say, as I said earlier, I had not understood Button. We all read it in law school. I had not understood Button to have that nuance until a couple of years ago. And so I understand the point. But on the other hand, the only way that case really makes sense is if you say that the lawyers had their own right, not just to petition, but rights pertinent to that. And by the way, pretty darn broad rights.
Counsel, doesn't the case make sense in terms of the Virginia law just prevented them from soliciting clients? And the U.S. Supreme Court said you can't prevent the NAACP from soliciting clients, holding meetings and events. It's a speech case rather than a petition case.
Well, it's interesting that you say that, but that's not what the court says. The court mentions the right to petition prominently in both the places, as I recall, within the space of one page, where it talks about the lawyers for the NAACP and the defense fund having this right. I understand your point, but that's not the way they cabined it. They included the right to petition quite clearly in the way they phrased it. Again, I understand the limits of Button, but they haven't been clearly laid out, certainly not in Tennessee.
Is there any court that has held there is a constitutional right, an independent constitutional right of an attorney to petition?
I don't know that there is. I'd have to look more carefully at that, but I don't know that there is.
And when courts have addressed this issue, haven't they generally said it's a personal right of the client?
I don't know that that's true either, Your Honor. I mean, apart from Jacoby and Myers, which I understand touches this issue. I get that.
Hasn't the Third Circuit weighed in on this, and the Colorado Supreme Court, and New York state courts, and aren't there a number of courts that have
You may be right, Your Honor. You may be right. Let me turn to one other main topic I want to talk about. I want to ask this court to consider, if the court's talking about downstream consequences of this ruling, a counterfactual hypothetical, and it's one that might well explain what we consider to be the legislature's view, expressed in plain language, that this should apply to my clients, okay? So now, mind you, we contend you should simply follow the TPPA's plain language, and that we don't need to show, and this court doesn't need to find, that there is some policy rationale specific to our facts that supports it in this particular case. But think about whether it would have made sense to have the TPPA's language mean that its protection was not based on whether the right to petition in question belonged to Mr. Cartwright or my clients or both. Because that's, again, how we contend the statute ought to be read. So consider where we'd be if Mr. Cartwright's actual position in this litigation were different. Suppose that once the underlying trust lawsuits were all over, all right, suppose Mr. Cartwright had not decided to sue his former lawyers, and suppose the Garners had decided to sue not only my clients, but also Mr. Cartwright over the filing of the trust lawsuit. So you got one lawsuit, Garner versus Cartwright and his former lawyers, okay? Under my clients and the Court of Appeals interpretation of the TPPA, both Mr. Cartwright and my clients could pursue a TPPA petition. The TPPA would apply. Under Mr. Cartwright's theory of what he would like the TPPA to mean, that would mean that Mr. Cartwright, as a defendant, could file a TPPA petition, but my clients could not. Now, I don't know how any of this members of this court would vote if they were in the legislature voting on this, but it certainly is a rational interpretation of what they did that might explain how this applies, that they wanted a broad interpretation that would include that scenario, not divide up a situation, say, well, you can't, the lawyer doesn't get a TPPA petition, but the client does. So I submit to the court that that might be a rational explanation for this policy, this interpretation based on the policy underlying it.
The other rational explanation could be the legislature can go back and amend statute if we don't interpret it that way.
Well, I suppose, Your Honor, that's certainly possible, absolutely. But then by the same token, the Texas example is pretty seriously on point in the sense of suggesting on language quite similar to Tennessee's. In fact, I think we've said in our briefs, I think it's pretty clear the legislature based the TPPA on the Texas law. There's a whole string of cases. We got a page worth of citations of cases down there that basically on a statute that looks like Tennessee's now, including on the points we've been discussing here, okay, that says, yeah, it applies. Legal malpractice cases, yeah, it applies. And the legislature, unhappy with that, comes back and amends the statute. It seems to me that's the simpler, clearer solution to this question.
Mr. Parrott, could I?
Sure.
I want to talk a little bit about the language in 105A. It seems to me that a lot of the work here, and one thing that I think distinguishes Tennessee's statute from Texas's and in some other states is that, well, actually, I don't know if this distinguishes it from Texas's, but is this language relates to. All right, so the legal action is based on, relates to, or is in response to. I mean, we typically interpret the language relates to pretty broadly, right? That kind of covers a lot of ground. It seems to me in this case that language is doing a lot of work. Mm-hmm. Because a lot of the allegations in the complaint are, based on not actual statements, but the failure to communicate or, things that are not themselves the filing of the litigation, but just things that happened in the course of the litigation. So I'm wondering if, you have any ideas about, a limiting principle for that language. I mean, even if here it's broad enough to kind of sweep all of this in, is there a limiting principle? I mean, let me just give you an example. Suppose that, you have some litigation in court and some really ill-behaved attorneys get into a little kerfuffle. And
could never happen, right?
Could never happen, but let's say there's a brawl in the courtroom. That would never happen.
This is getting interesting.
But I mean, just imagine this with me for a minute. So these lawyers get into a little fight, and it all happens kind of in the course of litigation. And one of the lawyers sues the victim. Ends up suing the other lawyer.
So it's an assault case arising out of a...
Yeah, it's a tort case. Is that related to? Is that a legal action that's related to the exercise of the right to petition?
One of the more interesting little nuances of Judge Stafford's opinion is his citation to Webster's for what relates to means. I can't remember if he gave a case cite too, but it's pretty broad. I don't have a strong answer for you, but I do think there is a limit to relates to. If anybody wanted to do a sort of, Brian Garner search on the word relate to and how it's used in case law, I'm sure we could come up with limiting cases that say relates to, but not, to attenuated from or something. I'm sure we could. But you've put your finger on the problem with the plaintiff's argument here, because what they're asking for is some kind of exception for legal malpractice. Okay, and if you approach it from that direction, which frankly might be required if you wanted to limit under relates to, we don't know what the plaintiff is arguing here or what this court could do. So this exception, would it be limited like under the California statute, which is sort of not in our statute, something in furtherance of the client's objectives? What about the cause of action? Does it have to be, we had some discussion in the briefing on that, does it have to be, a legal malpractice action, or what about assault or whatever? I don't know what exception they want or you could draw. What about the identity of the lawyer as a lawyer? All of those things, all of those kind of distinctions are extraneous to the plain language of the statute. Now, relates to, okay, you can cabin that with something like attenuated or something like that. I don't know. I don't know what it would be, honestly. But otherwise, what is being sought here and what was done in the trial court level is creating an exception. There's no question that's what was done. And if the court wants to go down that path, even indirectly, by somehow tinkering with how far relate goes, or the absence of a definite article, or the presence of, the absence of there, or whatever, however the court would choose to create an exception here, the court's going to have to define it. And all of those things I mentioned, it seems to me, have to be addressed.
Need to wind up, Mr. Pierre.
I'm done.
Well, I do
No,
want
I
to
think
ask the
unless
other court members any other questions. All right.
Thank you, Your Honor.
Thank you.
Appreciate it.
In rebuttal. We're not asking for we're not asking for a pronouncement from this court that the TPPA prevents all legal malpractice actions against an attorney. That's not what we're asking. It's fairly limited here, and it's been limited on the right that's being asserted or claimed, is the right to petition. The TPPA didn't change what the right to petition is or what it means under Article 1, Section 23, or the petition clause of the First Amendment. So you have to look, you can't look at the TPPA in a vacuum, so you have to look at what that right is before you get into the TPPA.
Counsel, let me ask you a question along that line. The statute plainly anticipates petitioning before a court. Mm-hmm. And as a contextual matter, people proceeding before courts make use of attorneys with regard to their filings. There's not limiting exclusionary language here. And if somebody's going into court to petition, we would anticipate they generally would be proceeding with an attorney. Why shouldn't we read that statute as part of serving the purpose under 102 as part of facilitating petition? This protective shield extends to the attorney.
Because and that's, to answer your question, it goes back to what I was talking about a second ago. It doesn't change what the right to petition is. So that right, who does that right belong to? If I'm representing myself and I'm pro se, it's my right. But if I hire an attorney who's representing me in a representative capacity, the law is clear on that, then is that attorney exercising the right to petition? If so, for whom?
Why isn't it
It's not the attorney's right.
Safeguarding the client's right to protect. Why isn't it part of safeguarding the client's right to protect the attorney here?
So the way the statute's written, and I'll explain that. So let's just assume that a lawsuit is the exercise of a right to petition. So in the underlying trust lawsuits, Mr. Cartwright, when he filed those suits, that was his right. He was exercising those rights. So in the statute clearly says, under 2017-105 subsection A, that when you're talking about the burden of proof, and this is what Judge Davies got this correct, is that you have to look at what the right to petition is under Article 1, Section 23 in the petition clause, and then look at the defendant's position. Have they been sued here for the exercise of their right to petition in those underlying suits? No, they have not. And I would say, also submit that the statute's pretty clear about that, and this is where Tennessee's is, the purpose part of our Anti-SLAPP Act is a little different than Texas's. And as an aside, Mr. Perry complains about the trial court citing to California law and Texas law. He was the one that introduced that into the mix. When we were before Judge Davies, it was them who introduced and asked the court to look at California and Texas law. But the Texas analog to section 2017-102 doesn't have this limiting language that it has to be consistent or necessary to implement the rights protected by Article 1, sections 19 and 23 of the Tennessee Constitution and the First Amendment. So, do they have a right to commit malpractice? No. So what if a lawyer files a petition on behalf of a client and they miss it by a day? You miss the statute limitations, and they get sued for legal malpractice. Were they exercising their right to petition? Would they be able to use the TPPA to get this dismissed? It's clearly malpractice. And let's not forget here what's happening here. They knew that if they refiled the 2 lawsuits, that they were time barred, and they filed them anyway and walked my client into the fines and the costs and the attorney's fees. They breached their fiduciary duty to my client in doing that, and they were trying to extort money from the Garners in these lawsuits. That's exactly what they were doing. So they come in and try to gloss over what the wrong, which we have to accept as true here, is pleaded at this stage, that they've been accused of doing. And that kind of takes me to, there is a public policy component on here too, and I think the panel has touched upon this, is like, where does that Jenga tower top off at, right? And again, if you go back to looking at the attorney that missed the statute, I don't think the General Assembly, I think the intent, or not what I think, but from the plain language, if you look at the act, the General Assembly did not intend to protect attorneys who were committing legal malpractice, because those aren't rights that are protected under Article 1, Section 23, or the petition clause. They're just not. As this court held the other day in Smith, and I'm reading on page 21 of Smith, the first sentence of the last paragraph of the coda, the conclusion. For the foregoing reasons, we hold Article 1, Section 23 of the Tennessee Constitution is enforceable against governmental entities, not private parties. So, if you look at those underlying lawsuits, the trust lawsuits, was any right under Article 1, Section 23 being enforced there? Under Smith, I would submit to the court that it could not be. So, and that's what this court has held. And the court also held in Smith, or recognized that the First Amendment, the cognate to Article 1, Section 23, are pretty much the same. They're in accord on how they're interpreted by courts. So, in my mind, this case is not as complicated as Mr. Perry makes it out to be. It's whose right to petition was being exercised in the underlying trust lawsuits. If the court decides that it was Mr. Cartwright's, which I think the case law seems to suggest, and the statute, the Texas statute suggests that would be the case, then their TPA petition should have been dismissed as it properly was. But again, we're not asking for some blanket protection for legal malpractice under the TPPA to be, well, let me back up. We're not saying that the TPPA does not apply to legal malpractice cases. But in this instance, we are asking the court to hold that the right to petition that in underlying trust lawsuits belong to Mr. Cartwright. And because of that, the defendants weren't exercising any sort of the right to petition, because you still, whose right does it belong to? And because they weren't exercising the right to petition for themselves, then the TPPA just doesn't apply by the express text to them in this case. And unless the court has any questions, I'm done.
Thank you both for
Thank
your
you.
fine arguments.
Thank you.
Mr. Paris, sit tight.
Yes, sir.
Everybody okay? Okay to go ahead? All right, we'll give you a moment and then ask the clerk to call the next case.
Alice Cartwright Garner et al. versus Thomason